live or work anywhere in their country, in any province or in any city they choose. The Charter of Rights ensures they can come and go as they please, a right often taken for granted.
That's very important in a federal country that calls itself a country, that a citizen be able to move anywhere he or she wants without restriction. That's a fundamental right of citizenship. The other fundamental aspect of mobility rights is the right to enter and leave the country, the right of every citizen to enter and leave the country. We've not had that problem in Canada, but we know of other societies where citizens have been effectively imprisoned within their own borders, and we regard that as intolerable.
For Native Canadians, mobility rights are additionally important. They're fundamental to supporting ancient cultures. The Charter reinforces the pursuit of traditional ways of life and livelihood across provincial borders. Dwight Dorey is National Chief of the Congress of Aboriginal Peoples. The organization supports almost 1 million off-reserve Aboriginal people in Canada.
When it comes to Aboriginal people specifically, who have hunting and fishing rights, mobility is extremely important. And traditionally, our people, under our traditional territories, covered pretty vast and large areas in the country, and the availability of resources in one area, or the lack of the availability of the resources, led to people moving around considerably, and it was part of our culture.
The Charter addresses a broad range of legal rights. Some of these were new, and some existed before 1982. They reflect a belief in human rights, impacting procedures for search and detainment and arrest and imprisonment.
The legal rights that are affected, influenced by the Charter and Charter decisions are very diverse and multifaceted, and involve a number of individual rights and community rights.
The Charter ensures the system of justice respects life, liberty, and the security of individuals. In a court of law, if you don't understand or speak the language in which the case is being heard, you have the right to the assistance of an interpreter. Like many legislative documents around the world, Canada's Charter is subject to interpretation. Critics of the Charter suggest the document gives undue power to the courts. In that interpretation, politicians are dodging their elected responsibilities and are delegating policymaking to judges.
Now, obviously, there are a number of people who argue that unelected judges should not have the right to overturn a decision of a majority of elected parliamentarians. And I understand that argument, but it misses a fundamental point of the Charter, and that is the Charter is there not to protect majorities any more than it is there to protect minorities.
T. Sher Singh was born in eastern India. Today, he's a successful lawyer and journalist. In 2002, he became a member of the Order of Canada.
It is not a perfect document, and that is why we have judges. If it was a perfect document, the legislators could go home, and the judges could go home and retire. We know that there will be times where we will need help to apply the law or to interpret the law, and so on and so forth. So that's the reason why we keep our parliamentarians busy. So as we find that we need to change the laws, fine-tune the laws, they keep working at it.
Well, the key problem about a charter, about any constitutional Bill of Rights, is how it's going to be interpreted and applied. And so much depends upon the cosmic coincidence of what judges are sitting on what cases at any given time. There's no inherent logic in this.
And when it is interpreted in a way that some of us do not like it, it is not fair to say that the judges are making law. That shows an ignorance of the due process in this country.
Politicians will jump at it. They say, let the courts decide. And we shouldn't let them get away with that, even if ultimately we want to bring a case to court.
and challenge what they've done.
The judiciary doesn't jump into the fray. It doesn't pick up an issue and says we're going to opine on it. We go to them. We go to them when we want to go, when we have an issue. We ask them for a reference. We ask them to rule on an issue. We ask them for an interpretation. We don't ask them to create a law. And if there is an ambiguity in the law, it is not the fault of the judiciary.
It was a decision made by our elected representatives to give the judges that power. Right or wrong, that was the decision that was created. Moreover, I would have thought, even if you don't like it, that the one time that you really want the judges to intervene, if you want them to intervene at all, is to protect vulnerable minorities against the majority. That's what you have these things for. It's to protect those vulnerable minorities.